on this. There. You're there. I think this is here.
Should I stay here or can I walk around?
Well,
or I have
if you
stay
want to
here?
advance, you can either use this button here, or I think you can use the mouse.
Okay.
But then if you want to go back, you gotta click there.
I should stay near the microphone, is that?
Yeah, if you could stay somewhat near the microphone, I think people will be able to hear you a little bit better in the
Okay,
back, because the
great.
acoustics are.
I'll try to talk
in this room.
not too loud. Thank you very much. I'm pleased to be in a room full of scientists like myself. I have a Bachelor of Arts in Political Science. No questions till the end. Yes, please. Stamford, Connecticut, 1 Landmark Square. Thanks. I thought that joke would go over a little better with the scientists here, but my firm is pretty much patent attorneys, so I live with scientists and these guys all the time, so we have to have a little humor. So, and the effort here today is to talk in a practical sense. We have slides. I've got notes on the slides. I'm happy to sort of have a conversation. It sounds like you guys are not nervous about conversing here. Try to keep a flow, and really just talking about, I'm not a patent attorney. I don't want to act like a patent attorney. Mike's in the room here, he can answer patent questions. My job, I do trademarks and copyrights, what we call soft IP in the world. I help you guys get your product, once it's been patented or invented, I help you market and sell the product. Your success is based on sales. That's what I try to help you with, and that's my job. I try to do the things that make sure that when you want to market and sell, you choose the right trademarks, you choose the right names and slogans and logos and things like that. The first slide is why is there interest? These are fairly common things now that are coming up for trademarks. Probably similar for patents and related IP. It gives you an advantage, and we'll talk about trademark in a little more specifics. These are just sort of starters here, and I guess unfortunately we went too far. Let me just go back one. Let's talk about the outline here first. And like I said, I'm just trying to give out practical advice. We're not here to fill out a trademark application form. We're not here to talk about the guts of filings and things like that. I'm really here to sort of talk about conceptually what's the best way to approach branding, trademarking your products. So you'll see here now, IP laws, trademark laws, they're going to protect your valuable interests on the one hand, but you're also going to run into problems if you don't do it right. So that's what we're here to talk about: selection, clearance, and protection of your trademarks. We're going to try to look at minimizing your liabilities and risk. And these slides, you can give me your card. I can email them to you. I don't know if Doug has got these available to you, so I can get these slides easily to you. And then we're looking at assets. This is an asset for the people who talk about, we've got investment people here. These are assets. Just like patents, trademarks are assets, especially when you talk about the big time trademarks. Those are real assets. And we see that as an IP firm. Due diligence is always in question about patents, now more so for trademarks. And we'll sort of talk about selection, filings, and ultimately policing your trademark at some stage here. Like I said, questions throughout. Please note that this is not legal advice. You need to consult with an attorney for specific legal advice. These are sort of just general comments. I'm trying to opine on areas that may be important to each of you here. So let me just throw out a couple of comments if I can. Here's what my scenario is. Somebody comes in last minute. I've got this invention. It's a box like Doug did. I'm going to sell it tomorrow. I need a trademark. Okay. You spent 3 years working on the box, and you want to spend 1 day coming up with a name. That's somewhat of the scenarios that I have with people. So that makes it a little difficult to go forward. I need a name. How do I come up with a name? So hopefully we can talk about that. How do you come up with a name? What's the effort? No one else has this product. I'm going to go out into the marketplace. Okay, no due diligence. There's hundreds of these products, hundreds of these names out there. So you're not the first one in. So there's a lot of things that lawyers can do, but there's a lot of things that the clients can do too. A lot of due diligence on their part. Trademark office has an easily accessible trademark database, so you can go there and find out about what names are out there. Googling, you can find out what names are out there. It's easy enough. So if you do that homework, it makes it a little easier for the lawyer to help analyze whether or not you do have a sort of a good trademark, a valuable trademark that should be protected. So those are the things. And I see there's a frustration because obviously we charge a lot of money to give advice. So it helps when the client comes in with that information and knowledge that they come in and say, I've done a little homework, I think this looks good, but I need some additional legal help. The goal here, obviously clients to make money. The lawyer's goal is to help assess risks and so that clients can make money. We assess risk because if Doug decides to put a trademark on his box and he grinds it on there and he finds out that his trademark infringes upon somebody's trademark that's out there already, Doug has to decide, my God, I just ordered 1,000 of these boxes. What do I do now? So that's pretty serious. So clearance, due diligence, finding out what the market's like, what kind of risks are out there. We can talk about that too. You can run into problems like that. You may have to throw away 1,000 boxes because you can't sell them. So there maybe that advice would be, maybe you don't want to grind it on your product. Maybe you want to put it in a box with a label on it so you can throw the box out but sell your box without a trademark on it. So there's some things that you can think about to help yourself too as we go along. Now let me get back on track. The interest in trademarks obviously gives you an exclusive right for an area. It's not a complete exclusive right. Trademarks are not patents. You have a right for the particular product and expansion of that area. Value to investors, venture capitalists, bankers, everybody sees these as assets, like we talked about. Goodwill, the more your product's out there, the more people enjoy your product, there's more goodwill, and there's quality. People know that when they want Crest toothpaste, they see Crest label, they get Crest. If you weren't able to trademark Crest or any of these trademarks, you wouldn't know what you're getting, so you wouldn't know what the goodwill is, so there'd be I don't know, chaos, but there'd be problems. Licensing. There's a lot of money that can be made in licensing today. So those are some things why there's an increased interest in trademarks. Probably not the same interest that you see in patents. Obviously, patents are more of a mainstay in products, but there are some values in your trademarks today. Okay, we talked about trademarks. What is it? Okay, here's some definitions of it. Generally, it's a name, a term, a slogan. It could be almost anything. Sounds, letters, colors that identifies your products or services and distinguishes them from others. Okay. Again, we're talking more about products here. I don't know if anybody has a concept of a service that they offer, wireless service, consulting service. We're talking more about products, but you can have a service mark. You can protect the service equally as much as you can protect the product. Again, trademarks a source identifier. So if somebody had a bottle of Coke, right? That's a source identifier. So you know when you get Coke, whether or not you buy it in Connecticut or you go out to California, you're going to get the same quality of product. You're going to know that that's Coke. You're not going to get Coke East, Coke West, Coke North, Coke South. It's the same quality of an indication. The law gives benefits to the manufacturer, the business, protects your investment. Coke's investment is protected. They spent a lot of money, lots of money, okay? A lot of goodwill, a lot of recognition. So that's protected so that the next guy that wants to be a Coca-Cola or a cola provider can't just go out and say, I'm gonna be Coke, okay? The law prevents that from happening. Flip side, just again, it benefits the consumer. Knows that if I go out and buy Coke, I'm gonna get the same Coke all the time. So there's a balance between the law gives the business guy a right to invest and protect his investment, consumers protected so they're not getting a lousy product at some point and they think they're gonna get a better product.
Does Coke have a patent on it?
Patent
It's Coke.
on the formula.
Yeah.
Well, we've heard the history is that their formula is a trade secret, which they protected, I guess, since Mr. Coke was created.
There's like 7 people who
Yeah.
who have access.
And then I think
Secret safe.
it's funny because a couple years ago, I don't know if you guys saw it, there was a story about a secretary in the Atlanta office apparently was being looked at as possibly trying to steal the formula, I guess, and they caught her before she, I think it's a she, before she let the secret out. But yeah, well, they may have the bottle design, as you see here, is protected by trademark. And I think if we go back again, Mike, you can help me out here, but if they did patent it, the patent would be long expired if they had a chemical formulation. These are some examples. We talk about trademarks. These are some of the examples. Yes. Yeah.
I think that when it first started, they had a design mark, and the design mark.
Well, they're gonna have a design patent, I think, on the
Design
bottle.
patent,
Yeah.
and then
Yeah.
that expired at that time, like 100 years ago.
Right.
When it expired, like in 14 years, which may be the same rate.
Right.
Yeah.
Right. And then because it's a source identifier, you don't need to see Coke on that bottle. You know it's Coke when you see that. It makes it a trademark. Just like slogans, symbols, and words.
How long is a trademark good for?
Trademark is good for as long as you're using the trademark. Not like patents and copyrights that have an expiration. Trademarks, the old adage, no trade, no trademark. That means as long as you're still in business, selling your products under those trademarks, you're going to keep that trademark. It's not. An example would be if you had a period of time for Coke, Coke would lose its right to, and then all the other guys would come in and say, well, we're going to be Coke too. Unlike, I guess, with the patent, eventually the patent expires, so everybody can go practice under that particular patent. There's a benefit on the trademark side. Does anybody know the first trademark registration? It's not that difficult, no. Adam and Eve sunblock. No, doesn't work? All right, well, going back into the 1870s, Bass Ale, the red design was registered as a trademark. And that was the first one in England. They registered it. Before that, they think that it goes back to maybe ancient times, the Roman Empire, where the blacksmiths, with the swords, they had to put emblems on the swords. I think that was the first indicator. But, so it goes back a long way. It goes back to somebody making a product and being able to say that that's my product, and that guy can't imitate and copy what I did, because that's the quality of my product. Sorry for the lousy joke.
Adam and Eve.
It's been a long day.
Adam and Eve did the Apple logo.
Yeah. They may be going after it. So.
I had a question.
Yep.
One of them you just showed, well, just do it. I don't even know who that is, but
The slogan,
it's
yeah,
like
Nike.
a friend of mine did one with like 2 little words, and they rejected it. They said those are common words. You can't do that.
Right.
And actually, the mistake was that he meant it as one word, but whoever sent it in, it had to put a little space between, so it wasn't clear. But once he removed the space, they said it was all right. But there's spaces in there.
We will talk a little about descriptiveness and issues about the names that you choose, the good names. you can squish two descriptive terms together and sort of make it look like a trademark. But the examination process sometimes will look beyond that and say, these are just two descriptive words put together, and therefore, by even putting them together, it doesn't create a distinctive trademark, okay? Usually what happens with descriptive marks, such as Just Do It, if you're a multi-billion-dollar corporation, you may get a registration pretty quick. Otherwise, you may have to be in the marketplace for a while. Don't leave home without it. We all look like a lot of us have gray hair here, so American Express, we probably came out, that looks like a nice slogan, but eventually it became so renowned that they went registered. So, and most of us would hear that and say, oh my God, that's American Express. Just like, I guess, today, people would say I don't know if they still use it or not, but they would recognize that. It's become not descriptive, but it has a secondary meaning. It doesn't mean just do it as a descriptive phrase. It means that's a source identifier for Nike products. That's a source identifier for American Express services. They've earned the right to protect that as a trademark or service mark. They've spent the money, they've got recognition, they've got the goodwill, so people can't take it, create confusion, and they would lose their rights. So you can gain your rights through a process of filing, of use, or a lot of use, going forward. I don't know if that, yep.
Could you say a word or two about color marks?
Color marks, there's something that, again, you can't get a color mark right from the start. You can't say if you had the color pink on your box and you tried to register it, you couldn't get a registration for it. You'd have to prove that in the marketplace, the color has become distinctive for audio boxes. Your sales and marketing would show that. Pink for insulation, Pink Panther. They had to, over a course of time, the color had to become distinctive of their products. Colors by themselves are not distinctive. Through use they are. Brown, the UPS, look for brown, those types of things, where you have to focus your energies on creating a brand. It just doesn't happen. You have to do something to instill the consumer to think, I should be looking for brown, I should be looking for pink, I should be looking for a color. The Supreme Court allowed color many years ago, but again, it allowed it based on circumstances that you had to prove that your trademark has become distinctive. These are terms of art, legal terms, which and from the get-go, you're just not going to get color.
What is the acid test for determining when you can obtain distinctiveness in the mind of the consumer?
Well, there's some tests. Some trademark office would say if you've been in the marketplace for 5 years, that's a prima facie proof, however. But you could say, no, I'm not waiting for 5 years. I've shown that bottle color red on that bottle. I've sold 1 billion bottles. I've been on the marketing and selling. I've been in every store. I've done tests. When people see that red, they think it's Coca-Cola. So we've become distinctive. So we have a protectable trademark. So there's not a 1 year, 2 year thing. It's an effort to show that you can do surveys. When people look and say, well, yeah, of course that's red is the color for Coca-Cola. It's not easily achieved, and primarily because there's not a lot of colors, so they don't want to have all the colors monopolized, which would prevent open competition generally with the use of colors.
Can jingles be trademarked?
Jingles?
Yeah.
If jingle like a long phrase or something like that. I mean, if
Like in the old days, like you said, most everybody's using gray. There was a lot of jingle advertisements.
Right.
Schaefer is the one.
Right.
Whatever.
It can if it serves as a source identifier. Again, if you can attach that jingle with the product, and the consumer thinks there's a connection between the two, then yes. If it's just a jingle that doesn't have any connection to a product or service, then it's just the jingle, and maybe you've got copyright protection for it or something other than that. But yeah, presumably the longer that jingle is, the harder it's going to be to protect it as a trademark, because people may not remember all the words in the jingle.
The most recognizable type jingle from research is Nabisco, and for eons, it's a multi-sensory one. So you say Nabisco, ping, and there's a ping, so it's got the music, it's got the name, it's got the red triangle. Research has shown that that's like the most memorable one because of all the sensory impact. So they're religious about not violating that ever. So it's welded in stone.
right.
Would you copyright a jingle instead or in addition?
If there's enough to it, I guess, sure. Probably there's lyrics and music that you can copyright.
As I was looking for the copyright to copyright Stir and Taste for the spoon, I found that, and
Do you mean trademark, or do you refer to you're referring to trademark? I
The
guess,
trademark,
right?
yes.
Yeah.
Scratch and Sniff, it was the prior, I guess, or whatever,
Uh-huh.
to allow Stir and Taste. But Scratch and Sniff was only allowed after they had been in the market for
Right. Yeah, I haven't done any homework on scratch and sniff, but I'm assuming it could be attached to, I'm not quite sure if it's literally attached to a scratch and sniff or something
is.
else.
Yeah.
No, it is, yeah.
Air fresheners
Yeah, through long use, yeah, like we talked about, yep.
And could you, and it's a silly question, but could he do a video using a spoon, because there was no other spoon like that, and copyright the video?
Of course, yep. Anything that's trapped in a medium like that, expression, videos, music, you standing in front of a camera, that's all protectable by copyright.
But he couldn't say like, good, right? Because somebody already.
Sure, I can.
If he's
Sure you can.
if he's got a good lawyer, he will. He'll defend him and,
Make you richer.
Yeah, so sue me.
yeah.
There you go.
We've got a couple more slides, but here are these issues that we can, we deal with a lot. And you guys maybe are thinking about, I think we talked about, you started an LLC, right? You just formed an LLC. So you're naming a new business, okay? We get this a lot on more of the infringement side. And I had an occasion to represent a hair salon recently where the infringer's defense was, well, we registered the name with the Secretary of State in New York, therefore we're immune to any liability because the government said that we can have the name. That's not the case. Government, they look at things, if it's not the same, they'll stamp it, rubber stamp it, and let it go through. Once you get into the marketplace, then the owners of those rights have to enforce their rights. So you can't defend it by saying, well, because New York said I could, I'm not infringing. So in your case, the non-advice, legal advice would be, you want to make sure that you do some searching to make sure that the name you choose, while you can get it, the Connecticut Secretary of State would approve it, you want to make sure that once you get into the marketplace, someone's not going to knock on your door and say, well, wait a minute now, you're infringing our trademark. And here's what's going on.
The goal was I chose a name that was pretty much non-existent, and not to put the cart before the horse, but trademark the name in the site.
Right.
Kind of not like kind of like an Amazon is trademark the name and also I believe what they do, like two different marks.
Right. Well, we'll talk a little about that. We can talk offline. Naming new products and services, we'll get into that a little more. Important enough is when you're looking at naming new products and services, you should, and this gentleman is talking about it, you should go get your domain that's the same or similar to your trademark. Sometimes you can get a domain and you can't get the trademark. Sometimes you can get either or, so you have to be careful. We spend a lot of time going after people who have stolen our clients' name embedded in domains. So, there's a whole trading practice, so it's stealing practice now. If anybody's familiar with the domains out there, the internet and all these registries, all they do is invent new registries to go out and steal trademarks, and they make money any way you can get it. They hold you the trademark owner ransom. They say, you pay us a lot of money and we'll not sell it to somebody else, and that's the way they make money, a lot of money. So you have to be careful. But the bottom line of the domains, you need a trademark to enforce your rights against a domain registry. That's more important than domains.
Wasn't there a Clinton administration ruling against people ransoming trademarks, ransoming domains for people who had the trademark already? You couldn't offer it for sale to them because it was whatever the term is.
Well, if it's not a court decision or law, what the government says people should do is not going to work. Okay, that's apparently nobody listened to them because that's what happens. If you read about it, that's where all the money's being made. The guys who did Y2K have moved on to making a lot of money in these new domain registries, which you have to be careful. I'm not, bigger companies are getting decimated by it. Maybe the smaller guys, not so much, not a problem about it. But,
Isn't it called trademark squatting or something?
cyber squatting.
Cyber
Squatting, yeah.
Could you give one instance?
Cyber squatting?
Yeah.
Pepsi, Cola, NewYork.com.
And they.
Well, I don't know, I'm just making it up. That's
No,
what happens. I'm trying to give you an example. That's what happens. Somebody would go and say, ooh, they never got Pepsi Cola in New York, so I'm gonna go get it. Okay, so let's wait. Maybe we'll wait to see if their lawyers come after us, and maybe we'll sell it to them or make some money off of it, and then the problems ensue from there. So there's a myriad of names that are out there that, I mean, the clients would go nuts, trying to enforce their rights against every conceivable matter. The bad guys originally it was all connected to porn sites, 9X misspelled with 2 X's goes to a porn site, Somebody made a lot of money because all of a sudden, people are trafficking in these sites. They don't know they're going there, but somebody's making money. That's really all it is advertising now. They're not really stealing your trademark intentionally because they like your trademark. They just know that you're a popular name, so people are going to misspell it, and they're going to hit sites that they're going to get paid for that traffic.
So you're saying basically register a business name and a domain site at the same time. So
Yeah. Yeah, if you can. Again, like I said, it may, depending on the name, the name may be, say for example, Delta, okay? Delta Airlines, Delta Faucet, there's Deltas all over the place. You may not be able to get what you want. You may have to extend your Delta into something else. But it's always good to try.
Is there a protection of a business name just depending on the space? For example, AB Faucet, and there's a space between A and B, and then Faucet. Someone else might come up with AB with no space between them.
You sound like a patent attorney, are you?
No.
No. In the real world, that's not going to work. Okay. In the patent world, that probably something we're going to talk about is that the patents. If you're in the 4 corners of a patent and you fall outside of it by one little doohickey, you're not violating a patent. But in the trademark world, that's not the case. The confusion is really the issue. Are the consumers going to be confused over these 2 companies, whether there's a space or a hyphen or one extra letter? And that's really the determination. Development of product packaging, that's important too. That's another source identifier, which colors, design shapes, things that attract the eye can help market your product and or service. And then eventually, as we talked about colors, you may have proven that those are right. You've used the color or a design shape on packaging so that people, I think Dell Computer used to have, if you took the Dell name off of it, you think, okay, that's a Dell package. So you've attracted somebody to your product even without using your trademark. And that's the reason is that the infringers know enough not to use your name, but know enough to put something on the box that makes it look like it's Dell, so somebody would mistakenly think they're getting a Dell, but they really got a Pell, but not Dell. So a lot of tricks of the trade that happens that people realize, or the counterfeiters or the guys that steal rights are in the know. Just sort of an aside, and when we're talking about these issues, I just wrote down a couple of when clients and lawyers are talking. I know we charge by the hour, but usually information's helpful. So a mute client doesn't help a lawyer do his job. So things like, tell me about your product, explain to it, what's your market, who you're going to sell to, what kind of consumers, how you're going to do these things. All of those things help formulate a legal position based on that information. If you're going to sell your product solely into this distribution chain where no one's going to see a trademark, no one's going to see it, you may not need to go through a process of registration. You may not need to do anything. It may not be worth it because who's going to be confused? No one's going to see it. Okay, that's an extreme example, but that's why the information can help. So when you're dealing with lawyers, you have to be more open. And I don't know if for the patent process too, the same thing, But here you have to do a little homework. You have to figure out who your clients, who your customers are, your clients. Where are you going to sell? Trademarks go beyond the scope of the U.S. They go around the world. So you may want to tell your lawyer that, hey, by the way, I'm going to sell in the U.S., Canada, and Europe. You may want to think about that. So you may have to do some searching, make sure that product X being sold in Canada may infringe a right, or Europe, so it may not be worth just looking in the U.S.
How do you secure your trademark international?
There's several ways to do that. One is if you're a U.S. business and you have U.S. plans for your trademark, you file in the U.S., and then you can use that filing. You've got 6 months. I don't know if your patent guys are familiar with PCT type things, where you can take that filing date and then move it into another jurisdiction. You can use that. You can go through the Madrid filing process, or you can hire a lawyer in Europe, file an application, or Japan, or wherever you want to go. And that's what we do. We have a network of people that we work with around the world, and we're doing that all the time. Hey, we have a client just filed in the U.S., they want to extend it to Europe. We go to them, we help them out, or we use the Madrid filing process.
What would the expected cost of a truly international trademark be?
There's over 150 jurisdictions in the world. Multiply 1,000 by 150, you've got a big number. So you want to choose wisely.
Plus maintenance fees.
And all that, yes, Mike. Yeah, I mean I just threw a number out. That's just a number. Multiply that by years of activity, and 150 countries. You're going to have people challenging your rights. You're going to be in oppositions. You're going to be infringements. It's not an inexpensive effort. So you really have to think about the trademark you choose, and go back to what I said. Where are you going to be? Does it really make sense to go through those steps? Because you're going to have to spend some money. I guess with the patent, you spend a lot of money and then you have to maintain it. You got your annuities, but those are come every 3 years. Probably not a lot more to it. Trademarks, somewhat the same thing, but trademark only has value if it's being used and being enforced. So, yes.
Is Europe is there a group, or is it each country?
For say for example, if you want to go to Europe, the European Union ex-UK, I guess, in a couple of years, Brexit, is 27 countries that you'd have protection in if you filed in the EU. Generally speaking, all the other countries are pretty much individual countries for filing. Yep, Mike?
Do you have, in Europe or overseas, do you have like common law trademark rights by use over there?
Some of the British common law countries sort of respect that interest, but a lot of countries base their rights on filing, statutory rights. So you could have a situation where in, say like France, you don't have a right unless you get a registration. In the UK, you've been out there, you've been selling, you've been using it, but you haven't registered it, you may have a right to enforce against an infringer. So you have to keep that in mind too. What happens a lot is clients that, some of our bigger clients, they know they're going to be in the marketplace. Some of the pharmaceutical companies, they go out and file in a lot of jurisdictions, keeping in mind that a lot of it are defensive filing, so that when the time is right, they're not sitting behind a situation where they're going to ship $1 billion of product only to find out that somebody already has the trademark and they can't do that. So.
In the 150 jurisdictions, to what extent is there commonality and reciprocity? And in some of the larger markets, China, Japan, regarding enforcement, it seems like I would guess that that's somewhat extremely difficult.
Right.
And what do you do in Japan? Go to the Yakuza and have
Yeah,
mustaches or something?
some countries don't really care for litigation and enforcement. China, I guess, eventually they're going to realize that if their citizens, their businesses become, proficient at what they do, they're going to want to protect trademark rights around the world, like IP rights, patents. So they're going to have to sort of shape up their borders too. But apparently they have cases now, but we have. I represent Danaher Motion. They have a company called Cole Morgan. And we registered the trademark Cole Morgan in our product areas, actuators and things of that nature. And somebody else came in and registered Cole Morgan in our category. And then we opposed, and Chinese guy said, no confusion.
Cole Morgan was a lot of high-tech
Yeah,
periscopes and so forth.
Yeah, oh yeah. So we're fighting in the Chinese trademark offices now over something that would be seemingly common sense. What do you mean? How can you have? We were there first. We've been there for 20 years. How can you allow this? It was it's a local company that did it. So you're fighting against some of the politics and things like that, and so it becomes sort of frustrating, especially with clients. The clients like, well, you must be a lousy lawyer. You can't protect our trademark. We registered already in a country. So frustrating.
So say
Yep.
you've got a patent in the United States and you didn't go for international patent, then once a product is doing really well, should you do it all at once, international and national, or can you get international patent?
Is that a trick question? You said patent. You meant trademark, right?
Or both.
Well, I don't know. Mike can answer on the patent side, but on the trademark side, unlike patent, you lose your rights at some point if you don't act. Trademarks, you get that window of opportunity to get the 6 months. So if you file today in the U.S., 6 months out when you file it, you get to bring that date back. So anybody that came in between, you trump. But after that, maybe a year from now, you say, "Wow, this product's going really well. We want to go in 10 more jurisdictions." You can file that trademark. The only issue is maybe somebody beat you to it once you get around to filing. You can't go back, but you can file patents. Mike, you're going to answer that part of it. I'm assuming that you may have lost your right to file a patent.
Yeah,
So
your trademark is a logo and the phrase within. It's all in one. Could somebody in another country copy that and then call it theirs?
Yep.
Oh, they can.
Yep.
Okay, so you got to do it all at once.
Yeah. Well, again, remember, it's something where you can search the records before you do something, and that's what we may get to. I don't know, but you can search and find out if somebody's already done that. we can give you advice to say, do it now, do it when you have a chance, but again, somebody has to pay for it, so if you don't have the money, so it doesn't make sense. So there's a risk, that's what we talk about, risk, what's the risk? Is there a high risk, is there a low risk? Is that point in time, 2 years from now, are you willing to change your name because you can't get into the market that you want to get into because somebody else has it? That's sort of judging and evaluation.
Okay, can I jump in there real quick about the patent?
Yeah, oh yeah, sure, I'm sorry, yeah.
And he's right, so for trademarks, like you said, there's a chance you can still get it after a year or 5 years, whatever. For a patent though, if you get a US patent first, let's say, you wait 2 years, then you say, hey, let's file in Europe, it's too late, the door is shut. Your own patent can be used against you as prior art, so you won't be able to get a patent in Europe. So you have to do it basically at the same time, or within 1 year file a what's called a PCT application.
1 year, you got a 1 year window between filing in US and filing abroad.
Right.
Yes, I registered a business as an LLC in New York State. So you're saying I can't sell in other states?
No, I'm not saying that. The trademark laws don't give you any permission to do anything. There's no law that says that. When you register in New York as a business, you can operate in New York as a business. You may have to.
And a website, kind of like you was talking, domain name.
Yeah, well, you may, if you're operating in other states, you may have to do some things in those states, like file DBAs or something. I don't want to even profess to know all about that. But when you sell under that trademark, then you potentially are, dealing with somebody else who may have prior rights under that name for that particular business.
In a different state.
It could be any state. Yeah, that somebody could have a federal registration for X. You register in New York for X plus, and you sell X plus into that guy's jurisdiction. He can say, X plus doesn't do it for me. I trump you. You have to stop. So you should be doing some type of clearance, due diligence to see when you do sell, do you have rights to sell wherever you're planning to sell?
Outside of the state.
Outside the
Doesn't
U.S.
cover-
It could be it could be in or out. If you haven't done either of those, you should be looking at your ability to freely sell your product. Because the internet it's great because you can get your product out there, but it's also, on the other side, somebody can find you pretty quick and come after you pretty quick. Because there's a lot of ways to find things on the internet that firms do. It's called policing of your trademark. Moving on to selecting protectable trademarks. That's what I'm talking about, is things that are not just merely descriptive. Oh, I've invented the box. What's the name for it? The box. Okay, let's move on. I think from my perspective, having spent 20 plus years in dealing with different types of products and services and different types of clients, if you could bring some imagination, some effort, some research, some due diligence into the process, it may be beneficial at the end of the day. I know you're a marketing person, so that's what maybe a lot of the people here don't have that sort of thought. They invented something and they think everybody's going to love this, the box. Okay. If you take it to a marketing person, they may say, who are you going to sell to? Well, I'm going to sell to 35-year-olds. Well, they're not going to know what the box means. You better pick a name that they understand. So, there's a legal implication of names. There's a marketing implication. Sometimes the legal part, descriptive names, the law, the courts don't like descriptive names. They don't want to give them out freely so that it interferes with free competition. If you have a descriptive name and it becomes distinctive, then the court will give you that benefit. But you have to earn it. You can't just come out of the gate and be the box, and the courts are going to say, nobody else can use the box. That's not gonna work. So be a little imaginative if you can. Maybe the box is gonna be sold to scientists, and they don't care what the name is, they just need to know that it's gonna do this, and that's all they want. So it depends on really what the market is, who the customers are, products, a lot of different things come into play. Yep.
So I understand there are certain trademarks which are considered strong because they're fanciful.
Right.
How do I know when it's fanciful? Like Exxon is a fanciful one.
Right.
But maybe Ardu Stomp is not so fanciful because it's descriptive. And so
Well, again, that's like that information flow. If I'm not political scientist, I don't know anything. So the client has to come to me and say, look, I want to choose this word, and they have to be honest and say, well, I chose this word because everybody in the industry loves this word. We all use it all the time. So, but I don't know it. Help me. I don't want to have to do a search and find out.
Well, let's say I came up with a name like Bobster.
Yeah.
Because it's
Right.
Bob and Stir,
Right.
it sounds like monsters. Is that fanciful, and how would I know?
It could be. You got to come to me. You're not going to know.
Gotta pay. Must pay to know.
No, I'm just kidding. We go in order here. We go from generic. At one time, it was a smartphone. Actually, when I was with 9X, people tried to register smartphone because before that there weren't any smartphones, and so our guys, engineers said, let's register smartphone, and it wasn't successful. 9X we tried to register voice dialing. Could you imagine that? Voice dialing? They wanted to register voice dialing. Okay. We weren't successful doing that. So, again, the scientists, the engineers, you all have a place to invent, but sometimes you gotta remove yourself from that part of it and go into where the professions are, marketing people who kind of can help you market your product. And then, guys like me, Mike, we can help you do the legal parts of it and clear it. Descriptive term, like we've talked about, secondary meaning. It's, when you heard vitamin water the first time, what did you think? Oh, it's gotta be water with some vitamins in it, right? Now you hear vitamin water, I think, I don't know. That's a branded product. So it's achieved trademark status and registration. Down the scale of protection, Citibank. Okay, I'm not really sure what a bank city is, so it's got a little more protection, give it some protection. And then the distinctive terms, coined, Google's, Exxon's, all these words that are sort of made up, they're not industry terms. Those are highly protectable. And then you look at the new context, Apple. Apple's in the dictionary, but it's, when it first came out, nobody knew what an Apple was until they had to be told that it was a computer. Camel cigarettes, they had to talk about cigarettes, but that's another word. When you heard Camel, maybe not today, but 20 years ago, you thought of a cigarette. Yep.
Well, Apple, it's really not, at the time, if someone had come to you and said, I got this computer, I'm gonna call it Apple, it doesn't really, it's not distinctive in and of itself.
Right, it's in a different context,
It's just, it became distinctive within that context, but as a trademark guy, if I came to you and said, oh, here's my computer, I'm gonna call it Apple, I don't think you'd say, great.
I think we would love it because, I don't have to do much work, right? It's not a computer, it's an Apple, and we don't have to, it's not a fast computer, it's not a box computer, it's an Apple. So the continuum of going down here, this is where, the top part is where, unfortunately, a lot of the marketing people in the telephone companies were 20 years ago. Just call it a smartphone. They've continued down the continuum saying, we should be better at this because the better you are, the more legal strength you get. The inverse is, I don't have to tell anybody what a smartphone is. It says it right there. It's a smartphone. I don't have to spend any money. It's a smartphone. So why should courts why should anybody give you any legal value, right?
But didn't Apple have a lawsuit with Apple Music when they picked
Yeah,
up with?
Yeah, because,
They certainly weren't competing.
They were time.
well, they were, I mean, they sort of moved it, and I think, rather than get all the niceties, I think they had an agreement at one point. They said they weren't gonna do some stuff, and they did, so, and I don't know all the details of it, but that's another part of it, yeah. I mean, you got a lot of things bumping in, we talked about Delta, you know, Delta. At some point, maybe there's agreements in place that the Delta faucets can't build airplanes, or something, you know, or something like that, yep.
Slightly different, so, I heard there was a guy whose name was McDonald who owned a restaurant before McDonald's came along, and McDonald's made him change the name of his restaurant, even though it was his name, he's been in business for years. So, if you don't have a trademark on your name, then you're at risk for being sort of.
No, that's not the case. If you have a name, whether it's McDonald's or Trump, who's the winery, the guy's going back many years, Ernest and Julio Gallo. If my name is Terrence Gallo, and I'm like, hey, wow, I'm going to sell wine now. I'm going to call it Gallo wine. And no, you can't do that. Just because your name's Gallo doesn't mean you get a right to sell a competitive product. They've earned the right to protect their interest against infringers. Now, I may be able to say this wine is produced by Terrence J. Gallo. You know, that's my name. I get to use my name, but I can't use it in a way that identifies sort of a source. So there's subtleties to the name. So McDonald's, I don't know all the details of that. I don't know if Mike, you know it, but I know Burger King, they had a problem. I think it was some location in either Florida or down south when they were rolling out. Somebody had Burger King already, so they had to sort of go around them, you know, and have their trademark rights, which is possible. You can have all types of that's. It's really what, you know, that's a lot of our work is not so much the routine is figuring out how do you coexist, how do you have consents, how do you make sure that one guy doesn't walk across the line into our area, and you can do that legally. Sometimes the consumers don't even realize, you know, those things are happening. So. Any other questions here before I?
Can I jump in real quick?
Yeah.
I grew up in San Antonio, and we had a burger restaurant called the Whopper Burger. And so for years, Burger King could not come into San Antonio. Whopper Burger had been there before, I guess Burger King, I don't know, but Whopper Burger had been there forever. And Burger King could not come into our location until Whopper Burger finally went out of business. Then Burger King went everywhere in San Antonio.
All right, so here's the continuum. You know, you go from dealing with your lawyer to he's trying to inspire you to come up with something really good, and you go through those fights and battles, and that's all I do is assess risk. Here's our first test. If I can use this correctly, okay. All right, so you want to be in the beer business, and here's our. I think there's probably thousands out there, but I picked 4. You guys are experts now. You have to find the one trademark that hasn't been agreed to by the trademark office as a trademark. Okay, there's actually 2 that have been approved and registered, 1 that's been rejected, and 1 that's still kind of pending. So take a close look and see. Anybody wanna jump in here and tell me which one's been rejected?
Home Brewing Company?
Wait a minute now, who's the ringer here? Anybody else agree? That's right. I knew I shouldn't have put it first. The trademark office said this home brewing company is merely descriptive of beer that is brewed in this concept of being out of your home, okay? Well, wait a minute, how come your beer tap, your home, how come they got it? How come Home Place Beer Company and Brewed in the Beer's hometown, how come they all got it, okay? Now this is just a sampling, I just put 4 here, there's probably 40 or 400 that have beer and home and not, okay. So this is an example of, from 2 perspectives. One is, really? You want to be another home brewing guy? You know, one of hundreds, thousands? Okay. As a lawyer, I'll try to help you. But this is what you get. The Home Place Beer Company just filed their application, so they haven't gotten through yet. Your beer, your tap, your home is Anheuser-Busch. So presumably they got it based on their size. And the Brewed in Beer's hometown is owned by Potosi Brewing of Milwaukee, Wisconsin. So here's the issues. Now you chose a descriptive term. The lawyer tried to convince you not to, but you did. You had to. You had to do this. You brewed this beer in your home, and so you're wedded with it. Now the lawyer has to. You got to go spend money. Now you don't have it. You don't have a registration. You can still use it. This is a trademark. You don't have to have a registration to use it. But now you've joined a crowd of others out there. Does that make sense? I don't know. I think from my end, I've seen this so many times. It's hard to convince somebody otherwise. That's where I would say, God, maybe you should have looked at the trademark office records. Don't you get a sense that home and brew for beer, it's a little diluted? How are you going to stand out? How is that possible? And that's what I think you should have, that feeling that how are you going to stand out? You may not be. This guy may have said, "Hey, I'm the first guy to brew beer at home." Okay, I'm the first guy that made a box that you can step on and transmit signals, right? Okay, but we don't know. I don't know. Maybe Mike knows on the technical side, but I don't know all that stuff. So you have to do a little homework and help yourself, because eventually your patent's going to expire. Your trademark can keep going. So your trademark is really going to be the point of interest at some point. So, all right, that's my political comments. Sorry for that. I get a little exaggerated. We talked about clearance. I don't know, how are we doing on time, Doug? Are we exhausted?
Yeah, I ought to wrap things up.
Right. Okay. You've got 55 more slides to go over.
Excellent.
Will they be on the site?
Yes.
Yeah, you'll have them. And here, I think I'm just really kind of repeating myself. This is the clearance part of it. This is where we want to evaluate risk. Okay, we want to look and find out, are these two is there going to be confusion? That's really the test. If you choose home brew and this guy's got brew home and you're going to sell beer, is there going to be confusion? Probably. Okay, you're selling the same product. Your names are the same or reversed. You're the same target audience. You're going to use the same trade channels. There's going to be confusion. Don't do it. Choose something else. Okay, that's customer confusion. That's really what trademarks are all about. Is the customer going to be confused, thinking that they're going to get Coke, but they got some schlock cola because there was something that looked like Coke on the bottle. That's confusion. You may need help. You did your own research. Oh, I checked the PTO site and I didn't find anything. Okay, then we look. Well, did you notice these things? Here's a bunch of trademarks. So I think it's valuable, especially if somebody like Doug is going to put his trademark on a box and going to sell. That's important. There's a quantifiable risk in doing that because there's an impact. Again, there's a lot of sources out there. You guys you're all scientists and all that. You can look at websites, PTO sites, Google. You can look at all that and get a sense of, does that name make sense? Spend some time. Don't just leave it to the end. Think about it during the process. Sometimes you may find you want to use a trademark for, a healthy granola bar, and it's also a trademark for, urine cleaner. Okay, all right. Maybe you should have done a little work there, huh? Don't leave it up to the lawyers to decide that. Maybe that's not the right name to pick. That's really, to me, that's somebody on the business side should be making those kind of choices, doing their homework. Yep.
How soon do you get to see what people have applied for, and how long is it from the time it's applied for till it's issued or approved?
Right. USPTO records are updated almost instantaneously because there are electronic filing. So within days, when things are filed. So it's a pretty active website. Not like the patents where you've got, things that are, not disclosed until publication.
You can see it before it's approved, Jack?
Yeah. Oh yeah. Yeah. Once we filed applications today for a client. Probably by tomorrow or the next day, it'll be a public record. And it's a public record. And then you can monitor it, see that it's gone through the cycle. Today, if you file today, you may get an action within, maybe 3 months to 6 months, depending on that window. So if you could get a registration, if it's based on use, you may be able to get a registration, no problems. A registration within 9 months to a year, if it really goes through quickly. If you file it based on proposed use, which this gentleman filed his application, he now has a notice of allowance. So now you have 3 years from that date to prove that you've used your trademark. So the process is there, but it could take much longer until you've got activity and use.
What if somebody sees it though and goes in with something very similar and they file it next week?
I mean, a trademark? Well, they're behind you. You have your trademark.
It's a little different.
Well, again, we talked about that. A little different. Generally, examination process will say, wait a minute now, there's no difference between bright diamond and bright diamond, BRITE or BRIGHT, okay, or whatever. Trademark examination process should, for the same product, they're going to say, wait a minute, the second guy, you can't have it. This guy's already got it. He's ahead of you. So that could go through. We have clients that have watching services, which means we pay a service to monitor applications, so that if bright diamond, somebody's trying to file for it, we get a notice that says, hey, Joe Blow's got brighter diamond, and then we make some decision based on that information. Yep.
What I had brought up before, so again, not to put the cart in front of the horse, but thinking about it, is it less costly, the same cost? Like if you want to trademark the site and the name, the product name, the names are identical. I don't know how it works.
You register based on the product or services that you offer. So, if you're going to sell, I'm not saying, yeah. So if the same name, it's just one name. Let's not use a name. Acme for widgets. Acme for widgets. That's all you're trying to register for. If you want to say, well, but I'm going to do more. I'm going to widgets. I'm going to do pumps. I'm going to do T-shirts. I'm going to do entertainment services, consulting. Then you have the ability to, in classifications, and you may have an increase in cost and things that flow from there.
Thank you.
The risks are. You want to go through the risks?
I was going to say, we have to get out of this library so we don't hold up our hosts, because they hate to
Okay.
if we stay too long. So if we could hold the questions and let Terry finish.
Yeah.
Slides.
Well, the risks, we sort of hinted at the risks. The risks are that you got to stop what you wanted to do. Okay, somebody says, hey, wait a minute now, you've got the same mark that I have. You have to stop. Usually it's a cease and desist letter, a demand. It could be somebody filed a lawsuit against you. Now you have to deal with that. And what are the issues? Okay, usually in trademark is the most important thing is get an injunction. Stop. We need you to stop. Okay. And what does that mean? Well, it means you have to stop. It means you have to not sell. It means you got to change your website. It means you have to change your marketing materials. You may have to go to suppliers. You may have, you've got a lot of things involved. So those are the things you think about right from the get-go when you're thinking about a trademark. Okay. You don't think about it when you're sued. you think about it in advance, and that's the risk that we're talking about. You could also be sued, you know, and the other side could try to get money from you, damages. Hey, Bryce, you sold the same product under my name, and you sold 1 million of them, you made $1 million, so that should be mine. So I got, you know, so you're gonna be fighting about money. So there's a lot of risk on the other end of the continuum of, I just picked the trademark and I just put it out there and I'm gonna take a risk. You know, that may not make sense. You know, so you have to think about, think about how that works. We have clients that say, you know what, it's going up on a website, I don't care. You know, if somebody sends me a letter, I'll take it off the website. It's all just it's a statement we're making. We're not selling products, so I don't care if they come after me. Okay, so that you evaluate the risk. You know, so again, I'm using Doug in his box. That's where I would be concerned. If you said, hey, you know, I'm gonna put my name on the box, and it's gonna, you know, I'm gonna make 1 million of them, and but I don't want to spend the money on lawyers or anything like that. I don't want to do any searches. You know, I don't think it's, you know, nobody's gonna. I looked up the name. I looked it up in the library. I looked at a couple of books, and I don't think anybody's gonna infringe my name. I'm only exaggerating. Now this is not a real situation. This is just a hypothetical. He's ready to
I made up the name yesterday, it must be good.
he's ready to fall over. Yeah, that would be, you know.
I'll tell you the story,
Yeah.
because it's interesting. I got the letter, the cease and desist letter, because I had an Arduino being shown in my video. And they said it's a counterfeit. I said, no, it's not. And I made a video just for them, showed them the box with the seal, has the trademark, broke the seal, showed them the back, had the trademark on it, showed them both sides. I said, look, it's legitimate. And they said, no, it's not. The color of that resistor is wrong. I got 3 degrees in computer engineering, and I'm showing them a computer. There's no way I could have known that was a fraudulent Arduino.
Yeah.
Got it on eBay, and it was cheap, so
These guys are,
and so I had to take it down from a Kickstarter page that had already been funded.
Yeah.
And I had thought it was a legit product.
Yeah.
And I got fooled.
That's
So
what
now
goes on.
I don't
yeah.
say Arduino Audio Shield on that because I know Arduino is a protected name. I just call it an Audio Shield. Now it's not a fancy full name, but if it was Loopster,
Well,
that would be okay.
you know what? Honestly, it doesn't have to be fanciful either. It could be a name that somebody already has for a box. So you just have to be careful. You know, I rail against descriptive names, but you know that's what the market's all about. Descriptive. You know, get it and register it, and then wait for the poor guy that thought he had a clear name, and now he's got we gotta negotiate.
Thankfully, the label on the box is a peel and stick. So if they don't like it, I can get it on the label, put it right on top, or just peel off the other one.
Yeah. The last page here, if I can find it, really just kind of goes through after clearance, filings, domains, customs. If you get a point where you've got a product and you want to prevent importing of infringing products, you can file with the customs. Watching services, again, that's sort of keeping an eye on who else is out there, what they're doing, are they potentially going to infringe your rights. Enforcement, cease and desist letters, policing your trademark. It's one thing to get a trademark, but if you don't police it, eventually you lose it. You know, you have all these examples of aspirin and escalator, all these, eventually, you just sort of lose them through dedication of, not claiming trademark status. You can go into the trademark office, you can oppose, you can cancel, federal court, and then your domains, UDRP action. So those, that's sort of a whiff of the problems, but that's something for maybe another program at a later date. And I think for me, the more important thing is, deciding if you want a trademark. There's some effort that goes into it. It's not an easy process. Not that it's not as complicated as going through the patent process, but it's something that can be valuable. And if your technology is not, if there's a lot of it out there, maybe a brand or trademark is going to, help you market your product versus the value of the patents or the technology. So That's it.
Well, thank after these meetings, sometimes we like to go out for a snack at one of the local diners. It's called Penny's Diner, 2200 Black Rock
Black
Turnpike.
Rock Turnpike.
Yeah, and is there anyone interested in going out afterwards? We got a couple, 4, 5. Terry, will you join
I
us?
can, I live in Westchester County, so it's gonna take me an hour or so to get home from here. I gotta
What
be at
town are you in?
Katona.
Oh my goodness. So you gotta go like Route 35 or something.
Yeah.
Take 123 north, that's the best way.
Yeah,
123.
get up to the Merritt and then,
Yeah.
yeah,
Yeah,
snake up.
if you get up, go up North Benson,
Yep.
and then to Black Rock Turnpike, you'll go right past it then.
All right, good. Well, I forgot what the next meeting is, but I think I can grab the computer here. I should be able to show it.
Let's see if I can. And turn off the